Well, an outburst in court during the sentencing trial of Parkland school shooter Nikolas Cruz came to an abrupt standstill when the defense called fewer than half of the 80 witnesses they said they would. Even the judge was upset. Take a look.
At this time, the defense rests, other than putting in our records.
We're not playing chess. I mean, I just want to say this is the most uncalled for, unprofessional way to try a case. You all knew about this, and even if you didn't make your decision till this morning, to have 22 people plus all of this staff and every attorney march into court, be waiting as if it's some kind of game. Now I have to send them home.
All right, now that is a rare move in a trial that could see Nikolas Cruz get the death penalty. So we are joined now by Rachel Fiset, a criminal defense attorney. Rachel, thanks so much for being with us. You know, the defense originally said they planned to call about 80 witnesses. They called just a third of that number. What is the strategy here?
I think what they are doing here is quitting while they believe they are ahead. There is something to the fact that it appeared that jurors may have been moved by prior testimony relating to mitigating circumstances of Nikolas Cruz, and that he had experienced some sort of damage in the womb from his mother's drinking and drug use. And they had witnesses testify to that, including an expert witness talking about the effects of drinking and drug use in the womb and how that could have affected Nikolas Cruz. And I think they thought this might be their most compelling evidence, and they stopped.
All right, so maybe quitting while they're ahead. This is definitely a jury trial, not a judge trial, which may be a good thing because, you know, we just saw that reaction from the judge today saying that these defense attorneys showed a level of unprofessionalism she'd never before experienced. You could see that she was visibly exasperated. Are you surprised by her reaction?
Well, if they're going to quit and they're not going to call, over half of their witnesses or 50 more witnesses that could have been called, what they then should do, and they have a decency, professional obligation to do, is let somebody know, okay, we're done. We're not taking the remaining 2 weeks that we said we were going to take. You call the judge's clerk, you let the prosecution know, we're going to rest our case. And that way everybody can prepare accordingly. So while they may have made somewhat of an abrupt decision to stop calling witnesses, at that moment, professionalism dictates that you let the other side know, you let the court know. This is a very big trial, and changes in schedule make a very big difference.
Absolutely. You just said, we're not going to call these 2 weeks worth of witnesses now. So I have to imagine, this changes the timing of the trial now. Is everything essentially moved up by 2 weeks?
Well, now the prosecution, who thought they had to prepare 2 more weeks based on 2 more weeks of witnesses, would have been under the gun to start their rebuttal case. Right. Normally the defense rests and the prosecution picks up from there and they begin to rebut and you have a smooth trial. I think in the defense's abruptness, now the jury goes and sits with the evidence they just heard, and the prosecution has to prepare its rebuttal, which now they look slightly unprepared in front of the jury. And I think the court will have to give it 2 weeks. I believe it will reconvene in about 2 weeks for the prosecution's rebuttal.
Yeah, so it could all be strategy here. Okay, Rachel, thank you so much. We appreciate it.
Thank you.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.